Well, we've all heard what has happened. We all know what is going on because this is, and I kid you not, the biggest event that has happened in my entire life. Yes, even bigger than COVID, even bigger than the Russia Ukraine war, even bigger than all the other things I've covered on this channel. Because for the first time in half a century, the most powerful country might finally let the states decide whether they want to murder their kids or not. So, of course, this isn't a complete victory. There are going to be places, shitholes like California and New York, that will still continue ruthlessly murdering their own children. But at the very least, there's actually some hope that some places, at least half of the U.S., will probably completely ban it. And I'll be honest, I could have never ever guessed this. I thought, U.S., especially under President Brandon, was completely lost, that there was no hope. And especially, since this law has been in place for 50 years, it's been super pushed by the mainstream liberal media. It's been accepted culturally by a huge amount of people. I just thought that honestly fighting against abortion would be, a good cause, but one that would never actually gain any traction anywhere. And yet the fact that the most powerful country in the world, Supreme Court, has now basically decided to end abortion is the greatest event that has happened in my entire life, and this is a historic moment. 2022 has seen more history probably than the entire rest of my life, which is kind of crazy because we're only 4 months in. So it's crazy. So I actually wrote the script a couple of days ago when it actually came out, but because I've just finished my first year of university, I haven't really had that much time because I've been doing a lot of other things. So now with that lengthy intro out of the way, let's finally get to what's happened. So of course, I think we all know what happened, but for those of you who are clicking on this video don't really know what happened, essentially, the U.S. Supreme Court has decided to overturn Roe versus Wade very soon and let abortion be, well, the issue of whether abortion should be legal or not, go back to the states. Now, yes, technically this hasn't happened yet because it was still in process and then someone leaked it, which, let's be honest, we all know what kind of person would be leaking that. Such a liberal, but, sorry, I just got a little COVID-19 there. Don't worry. Anyways, so that is what has happened. But, before we even talk, about my reaction, what my thoughts on this are, let's actually look at Roe versus Wade, because there are a lot of things in here that, to use a very modern phrase, are extremely sus. So let's do some research on what Roe versus Wade actually was. So we'll start our story exactly 51 years ago. And by 1971, elective abortion on demand was effectively available in Alaska, Washington, D.C., Washington State, Hawaii, New York, and of course, my favorite state, California. So, in that year, Shirley Wheeler was charged with manslaughter after Florida hospital staff reported her illegal abortion to the police, which is awesome. Wheeler was one of a few women who were prosecuted by their states for abortion. She received a sentence of 2 years probation, and as an option under her probation, chose to move back into her parents' house in North Carolina. Well, to be honest, for someone who just murdered her own child, that's a very light sentence, but at least they did something back then. So interestingly, the Playboy Foundation, which by the way is, one of the most virtuous, moral groups of people, the group that exploits women, and makes, billions and billions of dollars, and basically started the PORN industry, those guys, those moral paragons, they donated $3,500 to her defense fund, and Playboy magazine denounced her prosecution. So imagine my shock. Two degenerates teaming together to fight for something that is the most horrible evil imaginable. So the Boston Women's Abortion Coalition raised money and held a rally where attendees listened to speakers from the Women's National Abortion Action Coalition. So, this woman, there was a woman called Sarah Weddington, and she was persuaded to join Linda Coffey after listening to her give a speech about a new lawsuit she was going to file representing a woman and her husband. The suit would claim that the woman needed to be able to have abortions because the woman had a neurochemical disorder and should not give birth or raise children. Okay, so before we even get further in the story, having a disorder does not mean that you shouldn't give birth or raise children, especially a neurochemical disorder. Like, this isn't, some really bad thing. And to continue, they didn't want to abstain from sex, and contraception might fail. Okay, so here is essentially the abortion debate in a nutshell. So, you just don't want to have sex responsibly, and you might be using contraception, and a lot of the time you're not even doing so, but because you want to have the benefits without having the consequences of that, you're just going to murder the kid to punish that son or daughter of yours for your laziness and unwillingness to either abstain or, use contraception. But one lawsuit was not enough, since they wanted to go forum shopping to improve their chances of winning in court for this wicked thing. So they wanted to have another case so that they could end up with different judges due to the rotating system used for assigning cases to judges. Then, if either of them received a particular judge they thought would be sympathetic, they would ask to combine the cases. At first, she was unsuccessful in finding a suitable pregnant woman, and then in June 1969, 21-year-old Norma McCorvey discovered she was pregnant with her third child. Ordinarily, lawyers are not allowed to directly solicit clients without any prior relationship, but McCorvey's situation qualified for a loophole in the no solicitation rule, which allows lawyers to solicit new clients for public interest causes. So, cases. So, there's sus element number 2. McCorvey asked if she had what was needed to be part of the Weddington and Coffey's lawsuit. And she was told, yes, you're white, you're young, pregnant, and you want an abortion. And once again, this exemplifies the typical degenerate who gets an abortion anyway, a young, white, pregnant woman. So, lawyers asked McCorvey if she thought abortion should be legal. And McCorvey, who, again, if you're going to pick someone, you should at least pick someone with, some knowledge on it. She said she didn't even know. So, Weddington told her, it's just a piece of tissue and you just missed your period. And apparently, this was such compelling facts and logic that it convinced her that abortion should be legal. She agreed to let them represent her under the impression that she would be able to eventually get a legal abortion. She smoked an illegal drug and drank wine so that she would not have to think about a pregnancy. Again, not like the degenerates who support one degenerate cause end up doing a lot of other things like smoking, drinking wine, and smoking illegal drugs. But, of course, none of that was related. So she actually gave birth to a daughter at Dallas Osteopathic Hospital on June 2nd, 1970. The baby was adopted. So wait, so you're telling me that the very person whose entire abortion debate is revolved around didn't even abort the kid, which by the way is a great thing, but it's like, again, this just doesn't make any sense. But even though the child was already born in 1970, Coffey and Weddington filed suit in the United States District Court for the Northern District of Texas on behalf of McCorvey under the legal pseudonym Jane Roe. McCorvey's lawsuit was heard by 3-judge panel consisting of district court judges Sarah Hughes and William McLaughlin Taylor Jr. and the appellate judge Irving Loeb Goldberg, of the U.S. Court of Appeals for the Fifth Circuit. On June 17, 1970, the 3 judges unanimously ruled in her favor and declared the Texas law unconstitutional, finding that it violated the right to privacy found in the 9th Amendment. Yeah, because apparently, not killing your kids is violating the right to privacy. In addition, the court relied on Justice Arthur Goldberg's 1965 concurrence in Griswold versus Connecticut. So, this then reached the Supreme Court on appeal in 1970, and Justice William Douglas argued that the right to marital privacy and the limitation of family size from Griswold versus Connecticut also applied here, although he acknowledged that on the other side is my belief that many of many that the fetus once formed is a member of the human family and that mere personal inconvenience cannot justify the fetus's destruction. So even though this guy knew why it was wrong, he still was in favor of it anyways. He also challenged the majority opinion with a series of hypothetical questions, asking whether health might also include the stigma of having an illegitimate child that's not in any way related to health, anxiety from the pregnancy being unwanted, again, you chose to be pregnant, the physical work of raising a child, again, you chose to be pregnant, and the financial drain from the added expenses of another child, again, you chose to be pregnant. So, on January 22nd, 1973, the Supreme Court issued a 7-2 decision in favor of Jane Roe, in other words, Nora McCorvey, holding that women in the United States had a fundamental right to choose whether to have abortions without excessive government restriction, and striking down Texas's abortion ban as unconstitutional. The decision was issued together with a companion case, Doe versus Bolton, which involved a similar challenge to Georgia's abortion laws. So what the court reasoned was that outlawing abortions would infringe a woman's right to privacy for several reasons. Having unwanted children may, quote, force upon the woman a distressful life and future. Well, then again, you shouldn't have become pregnant. It may bring imminent psychological harm. Yeah, that's your own problem. Caring for the child may tax the mother's physical and mental health. Well, then don't be a mother. And because there may be, quote, distress for all concerned associated with an unwanted child. Again, like, you shouldn't have become pregnant. But the court rejected the notion that this right to privacy was absolute, and held instead that women's abortion's right must be balanced against other government interests, such as protecting the mother's health and protecting the life of the fetus. The court held that these government interests were sufficiently compelling to permit states to impose some limitations on pregnant women's right to choose to have an abortion, which, by the way, is not a right. Texas's lawyers had argued that its ban on all abortions except when a mother's life was in danger was justified because life began at the moment of conception, almost like that's true, and therefore the state's governmental interest in protecting parental life applied to all pregnancies regardless of their stage. But the court said that there was no indication that the Constitution's use of the word person was meant to include fetuses, even though, by the way, fetus comes from Latin meaning unborn person, and it rejected Texas' argument that a fetus should be considered a person with a legal and constitutional right to life. And yes, this is what all evil people do before they mass slaughter people, is they dehumanize whoever they're trying to kill. The court observed that there was still a great disagreement over when an unborn fetus becomes a living being. Yeah, I think the answer is pretty obvious, which is that it's when it's conceived. To balance women's rights to privacy and the state government's interests in protecting mothers' health and prenatal life, the court created the trimester framework. During the first trimester, when it was believed that the procedure was safer than childbirth, the court ruled that a state government could place no restrictions on women's ability to rip their kids bit by bit, other than imposing minimal medical safeguards, such as requiring them to be performed by licensed physicians. From the second trimester on, it ruled that evidence of increasing risk to the mother's health gave states a compelling interest that allowed them to enact medical regulations on abortion procedures so long as they were reasonable and narrowly tailored to protecting the mother's health. In the beginning of the third trimester, on the point at which a fetus became viable under the medical technology available at the time, the court ruled that a state's interest in protecting prenatal life is so compelling that it could legally prohibit all abortions except where necessary to protect the mother's life or health. Okay, well, that's very nice, except abortions ended up happening in all trimesters anyways, just as it would have inevitably happened, because once you allow a mother to murder her own child early on, she's not going to stop and say, oh, well, you know, it was wrong in the first trimester, but, well, it wasn't wrong in the first trimester, but now it's wrong in the second trimester. Eventually, they're going to allow it in the second and then the third, which already happens in the wonderful states of New York, California, etc. So, having completed its analysis, the court concluded that Texas abortion statutes were unconstitutional and struck them down. So, interestingly, and by the way, this is a complete coincidence, I'm sure there's no relationship. In the 1960s, there was an alliance between the population control and abortion rights movement. And after all, we all know that there is no alliance right now between the population control and abortion rights movement. But anyways, I'm just mentioning this because it's an interesting fact that I'm sure has nothing to do with anything. Abortion rights were especially supported by younger women within the population control movement. Again, I'm sure this is just a coincidence. Mostly the cooperation was due to feminists who wanted some of the popularity already enjoyed by the population control movement. In addition, population control advocates thought that legalizing abortion would help solve the coming population crisis, which demographers have projected. And they were right, because we did end up having a population crisis. We all ran out of food. We all ran out of oh wait, never mind. That never happened. In 1973, Hugh Moore's Population Crisis Committee and John Rockefeller III's Population Council both publicly supported abortion rights following Roe. Interesting how that works. Previously, public support for abortion rights within the population control movement instead came from less established organizations such as Zero Population Growth. I wonder who funds that. An exception was Planned Parenthood World Population, which supported repealing all laws against abortion in 1969. Together, population control and abortion rights advocates voiced the benefits of legalized abortion, such as smaller welfare costs. That's interesting because these are the same people who want more welfare. Fewer illegitimate births. Again, these are the people who want more illegitimate births. And slower population growth. Well, again, who benefits from slower population growth? I'll let you think about that. At the same time, the use of these arguments put them at odds with the civil rights leaders and Black Power activists, who were concerned that abortion would be used to eliminate non-whites, which, as you know, never happened. Oh wait, it did. H. Rap Brown denounced abortion as black genocide, which it basically is, and Dick Gregory said that his answer to genocide, quite simply, is 8 black kids and another one on the way, which is pretty epic if you ask me. So, back to Norma McCorvey, the woman who didn't even have an abortion, but thanks to her, abortion and murdering your kids became legal. She later claimed that during the 1970s, although some years after Roe, she had a nightmare concerning little babies lying around with daggers in their hearts. Well, who could have guessed that? This was the first of a series of recurring nightmares which kept her awake all at night. Well, it's almost like anyone with a conscience would kind of feel bad for allowing the mass slaughter of children, especially when basically 1 million Americans are murdered every year. She became worried and wondered, what had I really done? And, well, how did they kill a baby inside a mother's stomach anyways? So there we have it. The genius who allowed all this to happen didn't even know how abortions worked. So she said, I couldn't get the thought out of my mind. I realized it sounds very naive, especially for a woman who had already conceived and delivered 3 children. Although I'd seen and experienced more than my share of the world, there were some things about which I still didn't have a clue, and this was one of them. Ironically enough, Jane Roe may have known less about abortion than anyone else, and that tells you all you need to know about this case. So anyways, let's see what happened after. She initially joined with and accompanied others in the abortion rights movement. Within these years, she stated that she had publicly lied about being raped. Wow, imagine that. Imagine someone who wants to murder kids would also be a liar. Well, I could have never guessed something because, after all, someone who wants to kill their own children surely would never be bad enough to lie about rape. And then apologize for making the false rape claim. So, she also became part of the movement against abortion from 1995 until shortly before her death in 2017. And in 1998, she testified to Congress. It was my pseudonym, Jane Roe, which had been used to create the so-called right to abortion out of legal thin air. But Sarah Weddington and Linda Coffey never told me that what I was signing would allow women to come up to me 15, 20 years later and say, thank you for allowing me to have my 5 or 6 abortions. Without you, it wouldn't have been possible. Sarah never mentioned women using abortions as a form of birth control, which again, it's not like 50% of them are, but who cares? We talked about truly desperate and needy women, not women already wearing maternity clothes. Well, it's almost like if you allow people to do this, they're going to end up doing it. So, in 2002, along with Sandra Cano, Mary Doe from Doe vs. Bolton, and Bernard Nathanson, a co-founder of NARAL Pro-Choice America, McCorvey appeared in a television ad intended to get the Bush administration to nominate members to the Supreme Court who would oppose abortion. And so there we have it, the final conclusion. I mean, okay, I guess the positive part is at least she realized she was wrong and she had a conscience and then joined the movement against abortion, but still. The fact that they literally chose a woman who didn't abort her child, who had no idea what abortion even was, and who later regretted it, kind of shows the entire thing was a massive scam in the first place. It was all done through legal loopholes. It was done by choosing judges who would specifically be sympathetic to their evil cause. And again, there was nothing in the Constitution of the U.S. that said you have the right to slaughter your own kids. So overall, one of the most effed up cases, and I'm so glad that unless something drastic happens, this will finally be over. So anyways, we are gonna, pray for millions of kids who are gonna be saved because of this. And this is probably the greatest event that has happened in my life. Of course, as the traditionalists, we are fully pro-life, and I hope you are as well. Comment in the comment section down below if you are happy about this case as well. And if you are an atheist or a feminist who loves to murder their kids, maybe you should start off with your... Anyways, and there we have it. Go like, subscribe, and share, and I'll see you next time.